It might be all that.
No, it's not.
Oops. There's no, it's all or nothing, I take it.
Yeah.
Okay, folks, we're on the record 08CR 481, 08CR 481-001-002. We're also on the record in the 09 cases as well, 09CR 568-002 and 09CR 568-001. Now, is that all the 09 cases? We just had those two indictments come out in 2009. Is that correct, Mr. Johnson?
Yes.
Are there any other indictments down the pike anywhere that we might need to resolve? Okay, just making sure about that.
There's an order there that covers, matter of fact, it's in the plea agreement, that this covers everything up to today for which charges could be brought.
Okay. Rising out of these same set of circumstances and events during the time period, is that right?
I'm sorry?
Rising out of the same set of circumstances, events, facts during the same time period.
Right, or other things that are being investigated. An investigator has started and not reached the point where there are any charges being brought.
Fair enough.
All of that is
I just want to make sure we're done with this, we're done with that. Time period. Okay, if you would, counsel, for the record again, please identify yourselves along with your clients so we have a clear record.
I'm Dad Bolton. I represent
Good to see you. Yes, sir.
Paul Brown, representing
Good to see you. Okay, and has the Commonwealth made an offer that's going to be accepted in this matter?
We have, Your Honor, the offer for its continued court the signatures of all the parties, the attorneys, and the sheriff's signature also.
Okay, and
There are two offer forms. There's also a motion to reduce the asset forfeiture that's called for in the plea offer.
yes,
By $250,000 in order to allow the defendants to make a donation from their funds through the fiscal court for the alleviation of drug abuse in Harlan County, subject to, with the expenditure of the money being subject to the approval of the circuit judge. I have no objection to that. I think that's a good way to go.
and the reason being that it's going to the fiscal court is that they are the fiscal agent of this county, the people's fiscal agent that is created for the purpose of managing money. Is that correct?
That's correct.
It's not going to any private individual or private group or anything of that nature.
And it's for that purpose, things that would have an impact on drug abuse, things of that nature.
Which the board knows we need in this case.
Yes, sir. Thank you. Apologies. Does that refresh your recollection about the hearing that day, Your Honor?
That's pretty much the way I remember it. Yes, sir.
Okay. So that you knew at the time of that hearing that the bond forfeit, there had been a motion and outline for you for this bond forfeiture so that the forfeiture amount would be reduced to $500,000. Then $500,000 would be donated to the Harlan County Fiscal Court to alleviate drug abuse in Harlan County.
No, if I can answer the question.
Certainly.
Okay. You said alleviate drug abuse in Harlan County.
Yeah.
One of the things you need to realize is, before this actually came up here on the bench, or came before me on the court that day, is that the Commonwealth Attorney Henry Johnson had been in my office discussing the plea that was put out here on the record before this happened. As I explained earlier, Mr. Johnson had a real problem with this court refusing pleas on the record. It was one of those deals that he took it personally and that he would raise Cain if I refused a plea on the record. That's why I agreed with permission of the opposing counsel. If you note, the two opposing counsels on the tape there, on the film, were from out of town. And I said, it's good to see you again, because the last time I remember seeing them was either at the bond reduction hearing or the motion to dismiss for lack of jurisdiction hearing. The discussion I had with the Commonwealth Attorney at that time is that the Sheriff's Office, through their nonprofit organization, the Chaplains Corps, was wanting $50,000 of that donated funds. I was advised by Mr. Johnson that the defense counsel had brought up the notion of the donation. They were looking for a tax benefit, and I was told that in my office. At first blush, I was not overly thrilled with that. However, this case had gone on for some time, and as the case fleshed out, it became apparent to me that I didn't know if they were ever going to try it or ever get the case over with. The Commonwealth attorney was adamant that he wanted to resolve this thing through plea agreement, and the sheriff as well was adamant they wanted to resolve it through plea agreement. I relented to such a donation. As you note from the record, I made it clear that these donations were not going to any private entities. They weren't going to Joe Blow's donation fund, i.e. the Commonwealth attorney, the Sheriff's Department chaplain corps, $50,000, which I nixed in my chamber's discussions. Another thing that was on my mind that I had discussed with the Commonwealth attorney during those in-camera discussions, which he had approval of defense attorneys to do, was that I didn't feel comfortable any of this money going to the fiscal court unrestricted because the fiscal court was funding an assistant for the Commonwealth attorney's office. So what kind of job or judge would I be if I allowed a criminal defendant to make a donation that went to the Sheriff's Department, the arresting agency, and the money would end up with the Commonwealth attorney's office, the prosecuting agency? It was not the best of both worlds, but that was my thinking in regard to that. So when you asked the question, was it to alleviate drug abuse, the actual statement I was told in my chambers by the Commonwealth attorney, the agreement would be that I would make sure that the donation came from the clerk's office to the fiscal court for the drug prevention and alleviation of drug abuse in the youth of Harlan County through facilities and activities, was the exact discussion I had. You note Mr. Johnson just simply said out there, drug prevention. Well, there you go. It's going to end up with the chaplain's corps. It's going to end up with the Commonwealth attorney's office through a prosecutor through criminal cases. And that's the reason that I was making sure in the plea agreement, when I had my discussions with Mr. Johnson, it didn't end up that way.
Yeah.
So that's my answer to it, Mr. Mando.
And I'm going to show you what we marked as exhibit number 3.
Yes, sir.
This is the order in the Bolani case.
Yes.
In that particular order, that sets forth the terms of the forfeiture of the funds, correct?
It does.
And it says that it's consistent with the motion that was filed that we marked as Exhibit 1, and it says that the doctors are each going to, in that particular order, that doctor is going to give $250,000 to the Harlan County Fiscal Court as a donation to be used to alleviate drug abuse in Harlan County, with the use of such funds to be subject to approval of the judge of the Harlan Circuit Court. That's what that particular order provides, correct?
It does.
Right. And that's consistent with the language that's in the motion that you reviewed, correct?
That is.
Right. And that is consistent with what we just heard on the DVD in terms of what the terms were as outlined by Commonwealth Attorney Johnson, correct?
That is.
Right. And I assume then that you read that order and you signed it before it was entered into the record of the Harlan Circuit Court.
I did.
Then, on January 19th of 2011, Judge, did you appear before the Harlan County Fiscal Court at their meeting?
I did.
And at that particular meeting, did you address the fiscal court?
I did.
And at that particular meeting, did you advocate that that $500,000 donation made by those two doctors be used for a water park?
I personally advocated that it should be used. That was my personal opinion, yes.
And did you also, in the course of making your presentation to the fiscal court, report on research that you had done into the feasibility of a water park project, specifically that you had talked to some folks at Barberville and also talked to some folks in Sevierville, Tennessee, and they were willing to even send an engineer and an architect down to the fiscal court to talk to them about it?
I did do research when I had my children at the water park, and I did talk to them in Sevierville, Tennessee, not Sevierville.
I'm sorry.
Sevierville. That's all right.
My apologies.
We're close to Virginia and Tennessee, and Northern Kentucky's not quite there, so I'm sure it's kind of, it took me a while to learn the names in Ohio and all that. Did find out I had a bunch of cousins up in, what's that called? Norwood up there. So anyway.
My apologies for the pronunciation.
It's Sevierville. There's a water park there, and yes, I did discuss that with them. Yes.
And did you report to the fiscal court that you had been to Sevierville and that they were willing to send an engineer and an architect down to the fiscal court to talk with them about the water park project.
Yes, the people around the water park said they would love to help the children of Harlan County get a water park.
All
Yes.
right. And at that fiscal court meeting, did you also urge the fiscal court to move forward with the planning phase and finding a location for this water park?
I urged them personally to move forward with something for the children. A water park, whatever it was, something for the children. Yes.
And I want to be a little more specific. Do you recall using specifically the language that they should move forward with the planning phase and a location for this particular project?
I'm sure I did say that, yes.
And then at some point, Judge, during the course of this discussion and meeting with the fiscal court, it's my understanding that a question came up from Judge Grisham about whether these monies, some of these monies, could be given to the chaplain's corps. Do you recall that coming up at the meeting?
Absolutely, I recall.
And at that particular time, did you threaten to veto the expenditure of that money for the chaplain's corps?
Yes, I did.
And did you, at that same meeting, state before the fiscal court that carving out money for the chaplain's corps or for some other group not related to juveniles is illegal?
I did say that.
And that the court order gave you absolute veto power over that?
I did say a court order gave me the right to veto, yes.
And you recall using the words absolute veto power?
Absolutely, yes.
And you stated in question, there was a question asked about the scope of your veto power. Do you recall that?
Was that the one that came from David Kennedy, Magistrate David Kennedy?
It's hard for me to discern from the statements that I've gotten who the speaker was. I just saw a speaker, and it wasn't you, asking a question about
I would assume you're talking about David Kennedy. David Kennedy asked a question, yes.
And do you recall telling that particular magistrate then that you could veto anything that goes outside of that domain that you have in there, youth programs and facilities?
Yes, I did tell him that.
And your statements, sir, at least in summary form, were reported in the news media by the local paper in Harlan the following day, correct?
Let me say this. There was a story done by the Harlan Daily Enterprise. Mm-hmm. Whether the story reflected what happened or not, I can't say because I have zero confidence in the reporter and the newspaper that did that story.
All right.
And I could not get the tape from that hearing, the meeting that she had.
Mm-hmm.
She was the same reporter that Mr. Johnson met.
I understand.
And
Ms. Sizemore, I'm just asking, there was a report in the paper on the fiscal court meeting and the discussion about the water park and the $500,000, correct?
Yes.
Right.
Yes.
And and the story, as I saw it, reported that you spoke at the meeting. You don't dispute that.
No, sir, I do not.
And you advocated for the water park. You don't dispute that.
I personally advocated for a water park, yes.
And I talked about the veto power.
I used the word veto, yes.
All right. Now, do you have the Jesus? Let me show you what I'm going to mark as exhibit number 4.
Mm-hmm.
Judge, this is a letter dated March 3rd from the Judicial Conduct Commission to you.
Yes.
Signed by James Lawson on behalf of the commission. Do you recall receiving that particular letter?
I do recall receiving the letter.
All right. And in that particular letter, Mr. Lawson is bringing to your attention that there were 2 complaints filed, one having to do with the plea agreement in order of January 11th, as reported in the paper, and your authority to veto the expenditure of the funds that were donated. And then the second complaint had to do with the report of what you said at the fiscal court meeting on January 19th, correct?
May I take a moment and read
Sir,
it, sir?
absolutely. Absolutely.
March 3rd, 2010 has been some time ago for me. I've looked at a lot of things since then. Thank you. Okay, I'm familiar with it.
And my question was, I think I stated what that letter said, and I
Yes.
wanted to see if you generally agreed with that, instead of reading the whole thing line by line to you.
No, yes, generally.
Okay. And as a result of that, Judge, did you then do two things? Number one, enter an order on sign an order dated March 10th, entered March 11th in the Harlan Circuit Court, case number 08CR 4101 and 08CR 4102, and then also send a response to the commission dated March 11th.
May I see both of those, please?
Exhibits, the order I've marked is exhibit number 6, dated filed in the clerk's office March 11, 2010. Exhibit 5 is the March 11th letter from Judge Alred to the commission
Thank you.
for identification purposes.
So the order is number 6?
I'm sorry, not Judge, it was the order number 6.
The
Yes.
order was 6 and the response was the 5th. Yes, I did sign Exhibit 6, and I did send a response in Exhibit 5.
In the order dated dated March 10th, filed March 11th, which we've marked as exhibit number 6, you prepared that order and signed it, correct?
I did, or rather
Right.
my staff did, at my request.
And you obviously read it and approved it
Yes.
and signed it before you filed it with the clerk's office, correct?
Did.
And before you sent it on to Mr. Lawson at the commission, correct?
I never sent it to Mr. Lawson's commission, did I?
That order was never sent to Mr. Lawson?
No, sir, I did not.
Okay. In this particular order, Judge, you amend the January 11th order, and in it you reflect that the language quotes, with the use of these funds to be subject to the judge of the Harlan Circuit Court is hereby removed, correct?
Yes.
All right. Then you also said that the remainder of the order was to be left unchanged, correct?
Yes.
Right. And then you said in this order, this language was inadvertently put into this order by counsel for the defendants in the Commonwealth Attorney's Office. It was neither solicited nor approved by this judge, correct?
Correct.
All right. Judge, you had the motion that was filed, which set forth the terms of how that $500,000 was going to be donated to the fiscal court to alleviate drug abuse in Harlan County, with the funds subject to the approval of the Harlan Circuit Court. You had the hearing in which those same terms were set forth. You had the order that you entered on January 11th, setting forth those same terms. How can you say that that was neither solicited nor approved by you?
May I answer?
I asked a question. I was hoping for an answer. Thank you.
As I stated previously, Mr. Johnson, the Commonwealth Attorney, had been to my office on several occasions in regard to this ongoing plea agreement. If you'll check